grant of the same, the trial court ought to have been satisfied that there had been proper service of court process upon the appellant. I find and hold that there was no proof of service of the petition and the hearing notice upon the appellant. The appellant's constitutional right to a fair hearing is guaranteed, and Article 50 of the Constitution was violated in that he was condemned unheard. Consequently, all the orders made against Mr. Uhuru Muigai Kenyatta, as named by Mr. Olucher in his personal capacity, cannot stand. I would therefore set aside the declaration made by the High Court that Mr. Uhuru Muigai Kenyatta contravened Chapter 6 of the Constitution. Next issue whether the proceedings against Mr. Uhuru Muigai Kenyatta res judicata. I proceed to make the conclusion that, on my part, I cannot fault the findings made by the learned judges. I agree with them that the issue as to whether the President could establish a committee to initiate a change or amendment of the Constitution outside the remit of Articles 255 to 257 of the Constitution had not been raised in the earlier petition. The learned judges were therefore bound to hear and pronounce themselves on that important issue. The next issue is whether the Constitution Amendment Bill 2020 violated Article 43(1)(a) in view of the COVID-19 pandemic. Article 43(1)(a) states as follows, and I quote, "Every person has the right to the highest attainable standard of health, which includes the right to health care services, including reproductive health care." Mr. Omoke argued that the President was in total violation of the Constitution when he authorized or used public funds to initiate and promote the impugned bill amidst the COVID-19 pandemic. His argument was twofold. First, that since the country was and is still engulfed by a pandemic that poses a serious health challenge to all, the state should have prioritized the fight against the spread of COVID-19 virus by allocating sufficient resources rather than engaging in political activities. Secondly, the President and his agents, by organizing or attending what he termed as, I quote, massive super spreader events, including rallies and signature collection to promote the BBI agenda amidst the COVID-19 pandemic crisis, was a violation of Article 43(1)(a). It was also in disregard of the COVID-19 directives and regulations issued by the President himself and the Ministry of Health, banning public gatherings, maintenance of social order, and putting on masks, Council added. My conclusion on the matter is that while I agree that holding public rallies that are attended by thousands of people militates against COVID-19 mitigative measures, there was no empirical data or scientific evidence provided to the learned judges to enable them make a determinative finding that the holding of the said events per se amounted to a violation of Article 43(1)(a) of the Constitution. And regarding the amounts that were spent, my conclusion is that I find that there was no sufficient evidence to enable the learned judges reach a finding that the expenditure amounted to a constitutional violation. I will therefore dismiss that ground of the cross appeal. Next issue is whether both or either of the houses of Parliament were infirmed from considering the Constitution Amendment Bill in view of the Chief Justice's advisory for the dissolution of Parliament. I have found that there were orders that were issued by Justice Korir in several matters. The High Court observed that it was in the public interest not to subject the country to parliamentary elections before exhaustively interrogating the constitutionality of the advisory by the Chief Justice, and that public interest supported the issuance of an order suspending any decision to dissolve Parliament. The amendment bill was tabled before the National Assembly and the Senate on the 4th of March 2021 for the first reading. A vote on the amendment bill was taken in both houses on 6th and the 11th of May 2021, respectively. As at the date of tabling and voting on the amendment bill, the orders issued by the High Court suspending the implementation of the advisory by the Chief Justice were still in force, and there was no indication that the orders had been vacated. Accordingly, none of the Houses of Parliament was informed from considering any of the and or debating the amendment bill, owing to the advisory opinion by the Chief Justice. Next issue is whether the High Court erred in finding that the task force did not create a legitimate expectation on the submission by KNUN that it would be incorporated in the Constitutional Amendment Bill. I've looked at that, and my conclusion is that there is no demonstration. Sorry. In this regard, the fact that the proposals by KNUN were not incorporated in the amendment bill cannot be a basis of invalidating the amendment bill. It was not demonstrated that it was only the proposals by KNUN that were not incorporated in the amendment bill. For these reasons, I would dismiss the appeal by KNUN. Number 20, whether the petitioners had made out a case for disclosure and publication of the steering committee's financial information. I have considered what Mr. Morara said in that cross appeal and come to the conclusion that there is no demonstration at all by Mr. Morara that he requested for any information from the President, Honorable Raila Odinga, and the BBI steering committee regarding the budget and public funds allocated and utilized in promoting the impugned bill. The learned judges cannot therefore be faulted for declining to issue their aforesaid orders. Consequently, I would dismiss Mr. Morara's cross appeal on the issue. And the last one is whether the High Court erred in admitting Amishi Kuria, who are partisan. My conclusion is that, in my view, there is no evidence that the Amishi who were admitted to the High Court proceedings were biased. Their respective briefs were of great assistance to the learned judges in determining the issues I have alluded to. Although the Amishi were not parties to the High Court matters, having been admitted in the proceedings in that limited capacity, in the appeals, the first appellant named them as respondents, and therefore they had to file submissions in reply. I must add that I found the submissions quite useful in this appeal. Disposition. Having determined all the issues that we considered germane in these consolidated appeals, the final orders of the court are as follows. A. We uphold the judgment of the High Court to the extent that we affirm the following. 1. The basic structure doctrine is applicable in Kenya. Sichale J.A. dissenting. 2. The basic structure doctrine limits the amendment power set in Articles 255 to 257 of the Constitution. Sichale J.A. dissenting. For you? Yes. Okay. Sorry, I take this back. 2. The basic structure doctrine limits the amendment power set out in Articles 255 to 257 of the Constitution. Okwengu J.A. and Sichale J.A. dissenting. Number 3. The basic structure of the Constitution can only be altered through the primary constituent power, which must include 4 sequential processes, namely civic education, public participation and collection of views, constituent assembly debate, and ultimately a referendum. Okwengu, Katembu, and Sichale JGA dissenting. 4. Civil court proceedings can be instituted against the President or a person performing in the functions of the office of the President during their tenure of office in respect of anything done or not done contrary to the Constitution. Tuyot J.A. dissenting. 5. The President does not have authority under the Constitution to initiate changes to the Constitution, and that a constitutional amendment can only be initiated by Parliament through a parliamentary initiative under Article 256 or through a popular initiative under Article 257 of the Constitution. 6. The Steering Committee on the implementation of the Building Bridges to a United Kenya Task Force report, the BBI Steering Committee has no legal capacity to initiate any action towards promoting constitutional changes under Article 257 of the Constitution. 7. The Constitution of Kenya Amendment Bill 2020 is unconstitutional and a usurpation of the people's exercise of sovereign power. 8. The Constitution of Kenya Amendment Bill 2020 cannot be subjected to a referendum in the absence of evidence of continuous voter registration by the Independent Electoral and Boundaries Commission. Sichale J.A. dissenting. Number 9. The Independent Electoral and Boundaries Commission does not have the requisite quorum for purposes of carrying out its business relating to the conduct of the proposed referendum, including the verification whether the initiative as submitted by the Building Bridges Secretariat is supported by the requisite number of registered voters in accordance with Article 257(4) of the Constitution. Sichale J.A. dissenting. Number 10. At the time of the launch of the Constitution of Kenya Amendment Bill 2020 and the collection of endorsement signatures, there was neither legislation governing the collection, presentation, and verification of signatures, nor an adequate legal regulatory framework to govern the conduct of referenda. Sichale J.A. dissenting. Number 11. County assemblies and parliament cannot, as part of their constitutional mandate, change the contents of the Constitution of Kenya Amendment Bill 2020 initiated through a popular initiative under Article 257 of the Constitution. Number 12. The second schedule to the Constitution of Kenya Amendment Bill 2020, insofar as it purports to predetermine the allocation of the proposed additional 70 constituencies and to direct the Independent Electoral and Boundaries Commission on its function of constituency delimitation, is unconstitutional. Sichale J.A. dissenting. Number 13, the administrative procedures for the verification of signatures in support of the Constitution Amendment referendum made by the Independent Electoral Boundaries Commission are illegal, null and void, because they were made without quorum and in violation of sections 5, 6, and 11 of the Statutory Instruments Act 2013. Sichale J.A. dissenting. And 15, a permanent injunction be and is hereby issued restraining the Independent Electoral and Boundaries Commission from undertaking any processes required under Article 257(4) and 5 in respect of the Constitution of Kenya Amendment Bill 2020. B, we hereby set aside the following declarations and orders of the High Court. 1, that President Uhuru Muigai Kenyatta has contravened Chapter 6 of the Constitution and specifically Article 73(1)(a)(1) by initiating and promoting a constitutional change process contrary to the provisions of the Constitution on amendment of the Constitution. 2, that Article 257(10) of the Constitution requires all the specific proposed amendments to the Constitution be submitted as separate and distinct questions, referendum questions to the people. Nambuye, Okwengu, and Kiage JJA descending. 3, the BBI Steering Committee established by the President via Kenya Gazette Notice number 264 of 3rd January 2020 and published in a special issue of the Kenya Gazette of 10th January 2020 is an unconstitutional and unlawful entity. And lastly, the cross appeals fail and are hereby dismissed. This being a public interest matter, the parties shall bear their own costs in these appeals and in the High Court. In conclusion, on behalf of the entire bench that heard these unprecedented appeals, I wish to sincerely thank all the parties and their respective advocates for the diligent manner in which they argue these appeals and for the industry that they put in the preparation of all the useful material that was availed to the court. The authorities were so voluminous that time did not permit us to peruse and cite as many as we would have wished to. I found the submission